All right. Well, good afternoon and welcome to today's Privacy Watch. Wait, what? Not another state privacy law webinar. As you all are probably familiar by now, the world of privacy is ever changing, and we are offering these webinars to try to help keep everybody up to date. As we get started, a few pieces of housekeeping. We received a number of questions before the webinar. We have tried to design the webinar to answer those questions as we go through. I will note that a few of the questions related more to the TCPA and telemarketing regulations, and that's really outside the scope of today's webinar. Today's webinar is really focusing on state comprehensive privacy laws, and in particular, the new ones that have been passed so far this year. So for those of you who submitted a question more around TCPA or telemarketing, you're always free to give us a call or shoot us an email. We'll be happy to talk with you, but we may not be able to get into that today. If you have a question during today's webinar, feel free to put it into the Q&A box, and we'll try to answer as many of those as we can. And the ones we can't get to during the session, we'll try to follow up with you afterwards. We do have a lot of ground to cover today, so we might be a little pressed for time. This webinar will be recorded and will probably be available in about a week or so on our website. So if you do have to drop early, you can always pick up the recording there. During today's session, we're going to be using a lot of terms that some of you may be familiar with, but some of you may not, like controller and processor and targeted advertising. To help you with that, we've included a handy cheat sheet in the chat, which you can access on the screen. And so if you have any, oh, I may not exactly know what that word means, feel free to look at that cheat sheet. We tried to paraphrase some of the definitions for you so that they're more easy to understand, but of course, anytime you paraphrase something, you lose a little bit of the legal nuance. So I do just want to give that disclaimer that the definitions are paraphrased a bit. So my name is Josh Stevens. I am a partner here at McMurray & Schuster on the compliance side of the house, primarily focusing in privacy and telemarketing. Joined today by my associate, Aaron. You want to say hello?
Hello, I'm Aaron Parry. I'm an associate here at McMurray & Schuster. I work mostly on the compliance side, but also assist in the litigation side.
So a little jack of all trades over there, and a great resource here for the firm. Of course, any legal presentation, we got to start with the disclaimer. Lawyers like their disclaimers that this is an educational presentation. It is not tailored to anyone's specific factual circumstances. This is just to give a broad informational overview of a topic area. And of course, you shouldn't act on anything we talk about today without discussing it with your attorney, which hopefully is us, but if not, with whoever you're using, to make sure that the steps you're taking fit your factual circumstance. So I mentioned at the top of the intro that we do have a lot of ground to cover. States have been passing privacy laws at a breakneck pace, really since California passed its law in 2020. The gates have opened. Here on your screen is a map of states that have passed comprehensive privacy legislation. If you want this map, you can scan the QR code there on your screen. There will be another QR code on another resource document here in a couple slides as well that you can do that. I do want to give a brief disclaimer that we have colored Vermont in here with orange. Vermont's privacy law passed the legislature. When I checked this morning, it still hadn't been signed by the governor. There is a little bit of a question as to whether the governor is going to end up signing this law, but and that's we'll talk about this more in the enforcement section, but it does have a private right of action in it, which is a little different than some of the other states. So there is some debate on that. But as you can see, a lot of states with privacy laws coming into effect between now and 2026. And they all have some little pieces and nuance. Of course, not every state law is going to apply to every company. Each law has its own applicability requirements. And these do vary from framework to framework. So if you're thinking about California, for example, California's privacy law can be triggered by a revenue threshold, so $25 million a year in gross annual revenue, or it can be triggered by the amount of data that the business processes, as generally as a controller that is of residents of that state. Or you can have sort of a combination approach where the law is triggered by a revenue component. Maybe it's a percentage of revenue rather than a dollar amount of revenue that is associated with the sale of data, and a lower volume threshold for control. We're all kind of generally familiar with these requirements because we saw them in California, in Colorado, and Virginia, and those early adopter states. The newer states have generally followed this. There is variation, and you'll see that on the next slide. There is variation between those applicability thresholds with the different states. But a couple states had a really interesting take, which is Texas and Nebraska, where they've pulled in the definition of a small business as promulgated by the Small Business Administration, and basically said, if you are a small business, this doesn't apply, perhaps with a little exception here or there. And that's what they're using, which is the small business definition from the SBA focuses more around the number of employees or full-time employee equivalents. And so if you're a business that maybe doesn't meet the gross revenue threshold for California, or maybe you don't meet one of the normal state volume thresholds, but you are bigger than a small business for the SBA purposes, Texas and Nebraska may need to be at top of mind. These laws also have some common exceptions that you're probably familiar with, B2B and employee data being the two most common, every state except California. Nonprofits are generally exempt. Again, there's some nuance there. But where we see a lot of the play is with the GLBA exemption, which in California and Oregon being one of the new states, is focused on the data. So if data is subject to GLBA, then that data is exempt from the state law. But in the other states, for the most part, if you are a business regulated under GLBA, then you as a business are exempt from the law, which can be helpful for a lot of clients who are in financial services or are quasi-financial institutions like automotive dealerships. And so we're going to pop up on the screen here another resource document for you. And again, you don't need to take all this down right now, but use the QR code to grab it. And this is just a little chart we put together to help businesses think through the applicability thresholds for these new state laws. And as you can see, there is a lot of commonality, but there's also a decent bit of variation between the states. And one of the questions that we often get is, well, how do I handle this if I might be subject to more than one state law? And what we typically see from our clients is what we call the bucket approach, which is from an operational perspective and how they structure things. If a consumer is in a state that has a comprehensive privacy law, then they get the full suite of rights and they get the full suite of disclosures and they get everything that someone would get with the privacy laws applying, even if that means some overcompliance. So let's say you have California and Colorado as the two states that you're basing your comprehensive privacy program on, but you also have someone in Utah. Utah has slightly fewer rights than Colorado and California in certain respects. And so what we often see is clients will say, you know what, I'm just going to go ahead and give everything to the person in Utah because that's easier than trying to really do a state-by-state breakdown. We do have some clients who do the state-by-state. They're finding it very challenging. And so the bucket approach is often used. So as we get going here, I'm going to turn it over to Aaron, but real quick, there was a question about whether we'll be emailing slides or links. We will probably not be emailing the slides, but the recorded presentation will be available on our website here in probably about a week. And with that, Aaron, start us in on some of the substance of key parts of these new state laws. We're not going to be able to cover everything in every state law. We've only got an hour. But let's walk through some key provisions.
Yeah, so consumer rights principles are some of the most prominent aspects of our comprehensive data privacy laws, and they're crucial for several reasons. They help prevent unforeseen uses of data. They really help individuals have control over their information and to protect that information as they see fit. Luckily, most consumer privacy rights are similar across the board. Those would include our rights to know and access our information, delete, correct, opt out of certain processing activities, and to appeal denials of those rights by businesses. Now we've begun to see some states add additional rights that aren't common across the board, and a few of those are the right to obtain a list of third-party disclosures. We've now seen 4 states add that right. For example, in Delaware, that disclosure is a list of the categories of third parties to whom personal information was disclosed to. But in Maryland and Minnesota, they take it a step further, and controllers actually have to provide the list of specific third parties to whom personal information was disclosed to, if feasible. If not, they just have to disclose the list of specific third parties to whom any personal information was disclosed to. Minnesota, the most recent privacy bill to pass, it introduced this right to know about profiling decisions. And this right comes into play if profiling is used for decisions that have legally significant effects. That might be a decision related to the provision or denial of healthcare, finances, housing, employment. So if we're doing that type of profiling, then individuals have the right to question the result of the profiling, to know the reason why the decision resulted the way it did, and what actions the consumer could take to get a different result. And then if the information was based on inaccurate personal information, to have that personal information corrected and the decision reevaluated. So kind of our first impression here of this right to know about profiling decisions. California has a right to limit use of sensitive personal information. We'll talk about our heightened protections for sensitive personal information here in a few, and we'll kind of see where that right comes into play and how other states treat sensitive personal information. So in regards to our opt-outs, this seems to be the rights that are catching regulators' eyes the most, especially in California. Both of the actions that the California Privacy Protection Agency have taken against businesses involved selling personal information. The first case was Sephora. The Sephora didn't have a proper opt-out mechanism in place, and when their violation occurred, the cure period was still in effect, but they even failed to cure after the 30-day notice from the California Attorney General. DoorDash, the second monetary action, contributed data to a collective, and they didn't deem this as a transfer that required opt-outs, and so they weren't offering those opt-outs with regards to those certain transfers, and they received a $375,000 fine for that. There are specific requirements for responses in California, and most states don't go as far as California and enumerating exactly what a response has to include beyond appeals. All states say that appeal responses, when you deny a right, have to include a online mechanism that the consumer can contact the state's attorney general for. So one of those opt-out rights is the right to opt out of sale. And a sale is almost across the board defined as an exchange of personal information for monetary consideration or other valuable consideration. The latter part of that, the other valuable consideration, would tends to sweep in any type of disclosure where there is some type of value to either the disclosure or the recipient. So pretty broad catch-all there. There's specific carve-outs in each of the laws as to what does not constitute a sale. So it's really important to understand those. And that would be disclosures to a processor who's processing the personal information on behalf of your business, to a third party in instances where the consumer is specifically requesting that disclosure or is necessary to carry out to provide the product or service. And there's the list here indicates those permitted disclosures that don't constitute a sale and become really important when we're considering how and if we need to offer consumers the right to opt out of sales. In terms of consumer rights methods, generally the comprehensive state privacy laws require that the controller offer at least one method that takes into consideration the way that the consumer normally interacts with the controller. Those Texas and Nebraska, those two laws that Josh was talking about that have the kind of the nuanced applicability, they require two methods. And they expressly say that if you have a website, you have to offer an online mechanism. And if you're operating exclusively online, meaning you're not conducting any in-person business, you don't have any brick and mortar stores, and you have a direct relationship with the consumer, then you only have to offer an email. But the kind of top consideration is to have two methods. And these methods typically include a toll-free telephone number, an email address, a web form, or some clear and conspicuous link that will allow the consumer to exercise one of their rights. And for opt-outs, that clear and conspicuous link is required. You may have noticed these links on websites already. They're typically titled Your Privacy Choices, and they have the little blue and white icon. The purpose of that is to allow the consumer a quick and easy mechanism to effectuate their opt-outs. The laws that require this clear and conspicuous link require that link either effectuate the opt-out immediately or take the consumer to a web form where they can make the request there. Several states now are also requiring websites or controllers with websites to recognize universal opt-out mechanisms. And these are browser-specific codes that users can establish that will tell the website that we don't want that we want to opt out of all targeted advertising, sales, and profiling. And businesses now have to implement technological procedures to identify those opt-outs and to respond to them. Some of the challenges we've seen with this is it is highly technical, and there's some concern about how to effectuate an opt-out in other scenarios. If you're collecting personal information online and you see this browser-specific code come by, if you can't associate it with the consumer, especially. So just some considerations to be aware of as you're thinking about this universal opt-out requirement.
And just a couple of quick thoughts to interject there, Aaron. With regards to the universal opt-out mechanism, global privacy control is the one that's been generally recognized. California and Colorado have both recognized that. What's going to be interesting over time is if other of these universal opt-out mechanisms are developed and become standard and recognized, the legislative language has usually some fuzziness around when a business has to recognize an opt-out mechanism. So it'll be interesting to see how that develops. The other thing I will mention is that for those of you who've been working with CCPA compliance, you probably have a web form because CCPA regulations generally require a web form for consumers to exercise their rights. You may still have an email as an option. We are seeing clients who have had email as an option, pulling that back and going to just a web form and a toll-free number because those emails are sometimes getting spammed by bad actors in certain instances. And then in other instances, they're being used to funnel in privacy requests from vendors who are acting as authorized agents at very high volumes that become unmanageable. So the clients move to saying, no, you've got to put them in through the web form or the toll-free number. We can't just have you emailing us hundreds of requests. So just something to keep in mind as you're working through that issue.
Another pinnacle requirement under these comprehensive privacy laws is data security requirements. And generally, if you've had to comply with one of our sector-specific privacy laws, you probably have an information security program in place. But these state laws require the same. You have to have security protections that are appropriate to the volume and nature of the personal information you're collecting. Tennessee takes that a step further and requires that that your program conforms to the NIST standards and to any subsequent updates. Minnesota also put their unique touch on it, and they have a list of enumerated requirements that must be included in data privacy policy and procedures. And that would include certain descriptions of procedures regarding transparency, use, and non-discrimination obligations, procedures that reflect the requirements of the design of the controller system, and just overall a comprehensive view of the administrative, technical, and physical security practices of the business. So lately starting to see these security requirements under privacy laws getting ramped up a little bit and becoming just a little bit more onerous and a little bit different than what we're used to under our first few privacy laws.
Mm-hmm. Yeah, which makes complete sense, especially for a business that's dealing with sensitive personal information. And this is an area where we're seeing states taking particular interest. So sensitive PI is information that falls within a certain category, where it reveals or includes what some might consider more intimate or information that could cause harm if it's revealed. And you'll see here on the screen on the left some common types of sensitive personal information that generally pretty much all these laws recognize. And then on the right, some of the more unique ones, depending on the state. And this list is also available in the cheat sheet that's in the chat. So you don't need to scribble all this down. It's in that document as well. The concern with sensitive PI is that in most of these states, you need consent in order to process that sensitive PI. And consent is defined generally using the GDPR definition, which is a fairly onerous standard, right? That is informed, specific, freely given, and unambiguous. And if you look at the Colorado regulations, and I'll tell you that some of the regulators in the other states have indicated that they're going to follow the Colorado regs, that rather than sort of creating their own, that's how they're going to interpret their laws according to Colorado, because they've modeled their law in Colorado. If you look at the Colorado regs, consent is a high bar. It has specific disclosure requirements and actions that need to be taken. And so when you're going to collect and process sensitive PI, you really need to pay attention to those rules. California is a little more lax. It works on a limit standard, so you can collect it, you can use it, but then the consumer can object. Utah and Iowa, you don't need the consent up front, but the consumer can opt out. And remember how I mentioned consent has to be freely given. Well, part of freely given is freely revoked. So if a consumer gives you the consent to collect and process that sensitive personal information on day 1, and then on day 20 comes back and says, you know what, I'm opting out, I don't want you to process that, then you have to deal with that, and you have to typically delete that information. That's pretty much the only way to deal with that. There might be some exceptions you can rely on. Maryland really paid attention to sensitive PI in their law, and they introduced this concept that you can only collect that sensitive PI and use it where strictly necessary to provide or maintain a specific product or service required by the consumer. So it doesn't really even matter if the consumer consents, right? You can't even, you have to have this justification for collecting this information. And it'll be interesting to see if other states take a similar view over time, because most of these state laws also have a data minimization principle built into them that basically says you shouldn't be collecting, using, and storing more information than you need. And it'll be interesting to see if other regulators take the view that under the data minimization principle, particularly when it comes to sensitive PI, you really need to have a documented specific necessity for that. Maryland also has some very tight rules that basically say you can't sell SPI, and you can't sell any PI if you know the person's under 18, and that's part of a more age-appropriate design law that's kind of integrated into Maryland, which you'll hear us mention later. And that's another area where we're seeing a lot of state activity is on tightening up these privacy regulations and essentially treating if the data is from someone under 18 as if it's sensitive PI. So we'll have to really watch this area as we go along. And if you're a company that uses sensitive PI or uses data that you collect from someone under 18, this is something to really pay close attention to. And as I mentioned, consent requirements for the use of sensitive PI, there are other processing activities. So in these new state laws, pretty much with the exception of California, and California requires still consent in certain circumstances, but in most of these other state laws, including the new ones, consent's required to engage in a number of processing activities. I mentioned the sensitive PI, selling PI, engaging in profiling that has legal or similarly significant impacts, certain types of targeted advertising. It's using the data for what's sometimes referred to as a secondary use. That's the third bullet under consent here, which is where you want to use the data for something that wasn't disclosed to the consumer at the time the data was collected. We're really seeing the proliferation of consumer choice with regard to processing activities. And remember how I mentioned that generally, like the Texas law and the Nebraska law don't apply to small businesses. There is this like one little exception around selling sensitive personal information that it does still apply, even if everything else doesn't. And the last thing I'll mention with consent, like I said, it has to be freely given, which means it has to be freely revocable. Freely revocable means that it has to be just as easy to revoke the consent as to give the consent. You can't put up a bunch of barriers to the consumer exercising that right. And that's something we have seen some companies struggle with, is how to do that balancing where it is equally as easy to give as it is to take back. So besides just consent, right, in order to have consent, the consumer has to know what they're consenting to. So Aaron, talk about some of the disclosure obligations.
Yeah, it wasn't too long ago that I was going east on I-70 here through Columbus, and right before you hit downtown, we have this unique building that has space for two ginormous advertisements, and one of them was an Apple advertisement that just had the apple down in the bottom and privacy, period. And I got to thinking about it, and there's never been a time like right now where consumers want to know what's going on with their data. They want to be aware of how businesses are using it and what decisions are being made with it, especially with AI. And it's kind of a pillar of these privacy laws that businesses give that information. If you're like me, though, I click through the privacy policies with super speed, which is if you're doing that, though, I'd ask you next time, read through it, because it might have been one I drafted and it might have some beautiful prose in it, some Shakespearean type language. So take a look at it next time. But nonetheless, the privacy policy requirements mostly align across the board. California and Colorado, two of our three states with regulations, have kind of set the bar the highest. They have a whole enumerated list of information that has to be included in the privacy policy. But the other 15 or so states have kind of mostly aligned, and you'll see those. That's the categories of personal information you're collecting, how you're disclosing it to third parties, how consumers can exercise the rights granted under these laws. A few of the nuance requirements that we're starting to see now is that in Minnesota, if you recall, I told you about those data privacy policy and procedures that are now going to be required in Minnesota. You have to have a description of those policies. You have to have a retention period listed in your privacy policy. In other states, although this is fairly common, they require an email address or online mechanism to contact the business with questions about the privacy policy. One really unique requirement is that in Oregon, you must have your registered business name and any assumed business name that you're using in the state listed in the privacy policy. Texas has a couple unique obligations. They require that if you sell sensitive personal information or biometric information, that you have an exact disclosure of notice. We may sell your sensitive personal data. So starting to kind of see some divergence here with the privacy policy requirements. The privacy policies also have to be in a reasonably accessible location, and Minnesota has been the first state, and rightfully so, to introduce this concept that the privacy policy must be usable by disabled individuals. The APA or the APRA, which we'll hit on briefly toward the end, also has a similar requirement that the privacy policy be usable by disabled individuals. In terms of updates,
and Aaron, on that point, what's interesting there is kind of the breadth of the language, because some of many of the prior laws, like California, for example, say it has to be WCAG 2.1, right? There are these accessibility rules. But the breadth of the language in Minnesota, I think, is kind of what's interesting there.
Yeah, in terms of updates, California requires that privacy policies be updated at least every 12 months. And that is to ensure the most up-to-date practices are represented in the policy. But there's also some metrics compiling requirements for larger controllers that have to be updated every 12 months based on the number of privacy requests that were received in the previous calendar year. So updates in California, and then material changes. If you make a material change, which could include changes to the categories of personal information collected or processed, changes in the purpose for collecting or processing information, change in the identity of the business, any material change that may affect a consumer's decision to continue to allow or to not exercise one of their privacy rights will require a notification to the consumer and a reasonable opportunity for that consumer to withdraw consent. On top of our privacy policy, we're starting to see a lot of other notice obligations. Perhaps one you might recognize is the one right at the top of the list, the point of collection notice for California consumers. You may have noticed a California privacy notice link at the bottom of a website that you recently viewed, and that is a short form privacy policy that applies specifically to California consumers, but includes a reduced version of what they deem some of the more important information to get to the consumer before personal information is even collected. And that collection notice has to be on the home page and any page where personal information is collected. We have like I mentioned, a whole list of other notice requirements. If you're operating a loyalty program, or if you're offering a financial incentive to collect the consumer's data, you have to provide a notice if in response to a consumer's opt-out request, you notify that consumer that there's a conflict with the participation of the loyalty program or the financial incentive program. The third-party notice that Maryland introduced is unique to Maryland and requires that controllers provide a consumer with notice of newer changed practices before implementing those practices, and to notify them if there are any uses or disclosures of the consumer's personal information that is inconsistent with the promises made to the consumer at the time the information was collected.
Yeah, and the way that we, kind of flow through some of these obligations, of course, is by contract. And I think what happens sometimes is data controllers, they're busy and they're building products, and they don't necessarily think through all the contract requirements for sub-processors, and sometimes don't even realize that businesses who are acting as their processors need a contract. Also, when you are buying or selling data, that's obviously a point where a contract is needed as well. These laws generally have fairly consistent contract requirements for the service provider data processor relationship that require you to be fairly specific in what it is that the service provider is doing, what data they can use to do that with, how long they can retain that data, and to ensure that they're cooperating with you in honoring consumer rights and taking other steps that are needed to comply. California has some very specific service provider data processor contract requirements in their regulations. And I would encourage you, if you use a data processor, or if you are a data processor to a business that is a data controller subject to these laws, that you really go through your contracts and make sure that they're up to date with the latest version of the California regulations and with the requirements of these state laws, because they are quite complex and nuanced. With regard to third-party contracts, so this is when a data controller passes data to another data controller. Oftentimes we see this in a data sale relationship or sharing for targeted advertising. These laws don't really have a lot of rules around that in terms of the contracting, but California does. California, again, in their regulations has very specific requirements. So even if you think, well, this person's not accessing my processor, I'm just buying data from them or I'm selling data to them, you still need to definitely look at those California requirements and make sure that you're aligned with those. And you know how we were talking earlier about sensitive personal information? Well, beyond sensitive PI, certain types of processing come with what are viewed as heightened risks. And under these new state laws and under regulations that are coming out probably within the next year or so from California, setting a lot of specificity around this, a business needs to engage in what's called a data protection assessment. You might be familiar with the concept under GDPR of a data protection impact assessment, a DPIA. It's a similar concept. Colorado has very specific parameters in their regulations around this. And as I mentioned, a lot of the other states have indicated they're going to look to the Colorado regs to interpret theirs. But typically a DPA is required if you're engaging in targeted advertising, you're selling personal information, you're processing sensitive personal information, you're processing personal information for profiling that has certain risks or certain impacts. You'll hear the phrase legal or similarly significant impacts. Similarly significant are things like approving or denying credit or access to an important good or service like a utility, let's say, or maybe a vehicle. Or in California, in the employment relationship, right? Determining whether someone gets a job, keeps a job, is promoted. Those are all things that have similar impacts, similarly significant impacts. Or processing activities that just present a heightened risk of harm to a consumer. So financial harm, reputational harm, and the harm doesn't actually have to occur, right? It's creating an environment where that harm could occur. If you're engaging in that type of activity, then you need to conduct a DPA. And here on the screen, you see a few things that a DPA needs to include. This isn't a comprehensive list. Again, Colorado has specific rules. Minnesota wants you to talk about your data privacy policies. If children's data are involved, then there are other rules that come into play from Maryland and some of the other states related to children's data. So these are pretty complex analyses, but the idea is that you are documenting what your plan of processing is, the benefit to the consumer and to the business from that processing, the harms that could come from that processing, characterizing the likelihood and the impact of that, and then figuring out how do you mitigate those harms? How do you prevent those from occurring? Or if they could occur, that the consumer understands that they can occur. And sometimes in the course of the analysis, you may come to the conclusion that the risks are just so high and they can't be sufficiently mitigated. So we need to not engage in that processing. And that's an appropriate outcome as well. So these are written, detailed analyses that are done that have to be turned over to the state upon request. And one of the things that I'll caution you on with it is California and their regulations are actually going to determine a schedule by which businesses have to pre-file these. They have to just go ahead and just affirmatively file them with the privacy agency without waiting on the privacy agency to come back. Those regulations aren't finalized yet, but this is an important component that's been emphasized by these new state laws that have come out. And you're going to want to make sure that you abide by these laws, right? If you can, because there can be enforcement. You know, Aaron mentioned the DoorDash and Sephora instances, which both were around do not sell violations. Generally speaking, these laws don't have a private right of action. You heard me mention Vermont is an outlier here. Vermont, if it's signed by the governor, will have a private right of action for data brokers and what they refer to as large data holders, which has a specific definition in the law. In California, it has a limited private right of action in the data breach scenario. But these regulatory agencies are really interested in privacy issues. I just saw this morning an announcement from Texas that they're staffing up their privacy agency, getting ready to be one of the biggest enforcers. They were saying they were going to have the largest privacy enforcement division of any AG's office in the country. That's their plan. And so this is an area where regulators are really paying attention. We have seen in our firm a number of subpoenas and CIDs come out from states asking clients for information about their privacy practices. Now, some of these newer state laws, as you see on the screen, have right to cure periods. Not all of them do, and a lot of them have expirations on these right to cure periods, or the cure becomes kind of conditional. So while you may get a little bit of time early on in the life of the law to figure some things out, and if a violation crops up, you get a period to fix it, those generally are going to go away. There are some states where they won't, but in many states they will. And even if you do get a cure period, 30 or 60 or 90 days to cure something is not a lot, especially if you are a larger business that needs to really change a lot of internal processes and procedures with a lot of stakeholders. That can be really hard to do on 30 days notice or 60 days notice. So you really should aim for compliance. Every business has to make its decisions as to risk, but understand that if something comes up, you may have to implement and make a change very quickly if you took a risk on something. And these comprehensive state privacy laws aren't the only ones on the block. There are also a lot of new topic-specific laws that are coming up, and Aaron can tell us a little bit more about those.
Yeah, that's right. Along with our comprehensive privacy laws, we've seen these topic specific or industry specific laws being introduced and passed. The consumer health data privacy laws, which we now have in 4 states, Washington and Nevada, passed this apart from a comprehensive privacy law, whereas Connecticut and Maryland, Connecticut amended their comprehensive privacy law to include health data prohibitions. Maryland baked it into their privacy law, and these consumer health data privacy laws have broad applicability. Their intent is to regulate that health information that otherwise isn't protected by HIPAA. So broad applicability, a very expansive consumer health data definition that includes information that indicates a individual's past, present, or future medical condition, treatment, prescription, and includes information that is not by itself health information, but that could become health information if it's associated with certain types of other information. How I like to think about this is if you go into your local supermarket and you buy deodorant, that's not health data. Now, if you're putting that information into a perspiration tracking app where it's starting to identify health patterns related to your perspiration, it becomes consumer health data. So expansive definition there. These consumer health data laws also have unique and strict employee access restrictions, similar to our comprehensive privacy laws. They have service provider contract requirements. And in Washington and Nevada, they introduce a consent to collect versus written authorization to sell. The consent and written authorization standards are enumerated in those laws and really walk through exactly what disclosures you have to make, how the consumer has to give consent. But it's worth noting that there are increased consent or authorization requirements. There is a private right of action in Washington, so beware there. Our data breach notification laws, those are pretty much across the board in all states. Those require notice to certain individuals, the affected consumer, the state enforcement agency, typically the attorney general, maybe law enforcement, maybe credit reporting agencies. And those notice obligations kick in if a breach of information occurs where unauthorized access or some type of unauthorized acquiring of personal information occurs. We also have child privacy laws. These are those age-appropriate design code act laws that really impose additional compliance obligations for businesses that offer products or services to children or that are likely to be accessed by children. And they typically impose privacy by design requirements. You have to conduct data protection assessments. And a child under these laws are a bit different from COPPA. So COPPA, we're used to the understanding that a child is an individual under 13 years of age, but in these age-appropriate design code act laws, they bump the bar up, and a child's actually considered an individual under 18 years of age. So big gap difference and some important considerations. The difference between a 13-year-old and an 18-year-old, what they're interested in, what they might be viewing online, what they might be accessing, pretty significantly different. Similar to comprehensive privacy laws, these child privacy laws have require consent for certain processing activities. And as I mentioned, privacy by design principles, data protection assessments, similar to what Josh walked through earlier. And don't forget our industry specific laws. Those are still being enforced, probably now more than ever. And that's our GLBA, our HIPAA, our FCRA, COPPA, all of these kind of more long-standing privacy laws that either regulate a certain industry or a certain topic. Don't forget also Section 5 of the FTC Act, which prohibits unfair, deceptive acts or practices. If you are bored and looking for something to do, take a look on the FTC's site, and you can see just how they're using that Section 5 power to regulate privacy. And on to the big, interesting federal comprehensive privacy bill, the American Privacy Rights Act, introduced by a senator and a representative on different sides of the aisle. It's a bipartisan, bicameral bill that really appears to be gaining some traction. Just a couple weeks ago, on May 23rd, the U.S. House Committee on Energy and Commerce, the Subcommittee on Data, Innovation, and Commerce, voted this bill out of subcommittee. It's interesting how they voted it out, did it by voice vote. They didn't mark up the bill a whole lot. They didn't even tackle the fight over preemption or private right of action. They just, I'm assuming that was intentional and that these more significant debates and markups are going to come at the committee level. But it did take that first step and is now in for full committee consideration. The good news or the bad news, depending on what side of the spectrum you're looking at, is that it preempts comprehensive state privacy laws. We've walked through this patchwork. We're starting to see some onerous requirements now, some nuance requirements, some ways that we're really going to have to change our practices. And the American Privacy Rights Act does go further than a lot of our state comprehensive privacy laws, and impose kind of greater compliance obligations. And it does have this private right of action that we're going to touch on in a minute. But is that worth the knowing that, is that worth the trade-off between this patchwork of privacy laws? So whatever side you're on here, it may be good or bad that it preempts state privacy laws. So who does the APRA apply to? Well, it's applicable to controllers subject to the FTC Act, and it includes nonprofits and common carriers, which really kind of sweeps in a lot of businesses. There are exemptions for small businesses. They don't use the SBA's definition, but that's a business that has $40 million or less in annual revenue, and they process the information of 200,000 individuals or less. So exemptions there. There is a data-based entity for data subject to certain federal laws like the GLBA and HIPAA. That's data-based only, not entity wide. So beware there that you're most likely going to have obligations here. Does exempt employee data. Another big part of the APRA is that it really aims to regulate data brokers. Data brokers have to make a disclosure on their webpage that they are a data broker, and that the consumer may exercise rights to opt out. A data broker is a covered entity whose principal source of revenue is derived from processing covered data that entity did not collect directly from the consumer. There is an annual registration requirement. We've seen this pop up in California, Texas, Vermont has data broker registration requirements. And the APRA kind of carries that as well. It's an annual registration if you're acting as a data broker with respect to greater than 5,000 consumers' personal information. That's $100 annual registration fee with the FTC. That'll be a publicly available database. And as part of that registration, you're going to sign yourself up to receive do not collect and delete my data requests from the FTC. This is a mechanism where consumers can go in quickly and effectuate both a request for a data broker not to collect their information and to delete any information that they have on file for that consumer, and you have to comply with that within 30 days. There is a private right of action for violation of most parts of the APRA. Some reports say it's a limited private right of action, but when you actually read into it, it's limited in the sense that it doesn't apply to the entire bill. They expressly carve out the sections of the bill that the private right of action applies to. It just so happens that those sections of the bill are the ones with the obligations in them. In terms of enforcement, the FTC, subject to appropriations by Congress, will create a new bureau to carry out the enforcement investigation of the granted to them under the APRA. Enforcement will also be granted to states. States will have power to enforce it. They do limit it in a sense that only one state can bring an action for the same violation. So you won't expect, if you do violate the law, to have each of the 50 states knocking at your door demanding a civil penalty or something. So it's kind of nice there. States also are reserved the power to make any claim of a violation of state law. So Josh, I mean, what do you think? Is the APRA close, or where are we headed?
Well, it's certainly the one that's gotten the most momentum behind it. I still think that there's a lot to be worked through, and particularly that preemption issue. States that have comprehensive privacy laws and have put the time in for that are probably going to be fairly resistant to having their laws preempted. But, business would really like to see some consistency across the country. So we'll have to see. We'll have to see what happens. It's going to be a wild time, and heading into an election season always adds another layer to it. And I see that we are at time, so we're going to go ahead and close out here. If you have any questions that you weren't able to post today, or you just think of afterwards, feel free to email us. Our emails are here on the screen, and we'll be happy to get in touch with you. And as always, thank you for attending today's session, and we look forward to seeing you on a future privacy webinar.